and so sought to insulate the election process from the deleterious perils and malaise of opacity, corruption, crime, and malpractice. The antidote they prescribed was an electoral system founded on and infused with clearly defined core principles, including, in particular, free and fair elections that are conducted by an independent body, are transparent in character, and administered in an impartial, neutral, efficient, accurate, and accountable manner. This appeal, as were the proceedings giving rise to it, are a call to the judiciary to authoritatively pronounce on whether these constitutional principles are upheld and given effect to, or are violated and infringed by certain provisions of the Elections Act, and we'll refer to it as the Act from here on, and the regulations made thereunder, insofar as they relate to the results of presidential elections. It is a question of first importance that implicates this Court's understanding of electoral accountability, the sanctity of the vote, the giving effect to the will of the people in the manner of elections as its overall constitutional philosophy. The appeal arises from the judgment and decree of a three-judge bench of the High Court, that is the Justices Mchelule, Korir, and Muita, delivered on the 7th of April 2017. The judgment was rendered in a constitutional petition filed by Maina Kiai, Khalif Khalifa, and Tirop Kitur, that is the first, second, and third respondents, respectively, against the Independent Electoral and Boundaries Commission, the appellant, and the Attorney General, the fourth respondent. The petition was filed pursuant to Article 165, subsection 3D of the Constitution, and sought declarations regarding the constitutionality of provisions of the Act and the Elections General Regulations 2012, which we'll refer to as the regulations hereafter, which are specified below. The petition was brought against the appellant as the body charged under Article 88 of the Constitution with the responsibility of conducting and supervising free and fair elections in Kenya. For his part, the fourth respondent was sued in his capacity as the principal legal advisor to the government, who is also responsible for representing it in legal proceedings and for promoting, protecting, and upholding the rule of law and defending the public interest. The first, second, and third respondents prayed for the following reliefs in their petitions. And I quote, A declaratory order that sections 39, subsection 2 and 3 of the Elections Act 2011 are contrary to the provisions of Article 86 and 138, subsection 2 of the Constitution, and are therefore null and void. B, a declaratory order that regulations 83, subsection 2, 84, subsection 1, and 87, subsection 2 of the Elections General Regulations 2012 are unconstitutional and contrary to Articles 86B and C and 138(2) of the Constitution, and therefore null and void. C, a declaration that respective constituency returning officers are the persons responsible for the conduct and declaration of constituency presidential election results. D, a declaration that constituency presidential elections results, once declared and announced by respective constituency returning officers, are final results for the purposes of that election. And E, a declaration that constituency returning officers possess a fundamental and an inalienable mandate to announce and declare the final results of a presidential election at constituency level, and that such declaration is final and is not subject to alteration, confirmation, or adulteration by any person or authority other than an election court pursuant to Article 8.6 and 138(2) of the Constitution of Kenya. Close quotes. The appellant and the fourth respondent oppose the petition on the grounds that the High Court did not have jurisdiction to hear and determine the matter because the question raised therein related to presidential elections which were exclusively reserved by the Constitution for the Supreme Court, that the issues raised in the petition were res judicata, having been raised and determined in the case of Raila Odinga and 2 others versus IBC and 3 others, and that in any event the impugned provisions of the Act and the regulations were not unconstitutional. Before the hearing of the petition, the fifth respondent, Katiba International, a legal non-governmental organization focusing on the implementation of the Constitution of Kenya, applied and were admitted to the petition as amicus curiae and permitted to make written and oral submissions on the dispute. The petition was subsequently determined on the basis of the pleadings on record, as well as written and oral submissions. Upon hearing the parties, the High Court held that it had jurisdiction to hear and determine the petition, and that the issues raised in the petition were not res judicata, and allowed the petition in the following terms. And I quote, A, it is declared that to the extent that Section 39(2) and 3 of the Elections Act provides that the presidential elections results declared by the constituency returning officers are provisional, it is contrary to Article 86 and 138(2) of the Constitution and is therefore null and void. B, it is declared that to the extent that Regulation 87(2)(c) of the Elections General Regulation 2012 provide that presidential election results declared by the constituency returning officer are provisional, it is contrary to Article 86 and 138(2) of the Constitution and is therefore null and void. C, it is declared that to the extent that Regulation 83(2) of the Elections General Regulations 2012 provides that presidential election results declared by the constituency returning officers are subject to confirmation by the Commission, it is contrary to Articles 86, 138(2) of the Constitution and is therefore null and void. D, it is declared that the presidential election results declared by the constituency returning officer are final in respect of the constituency and can only be questioned by the election court. And E, it is declared that to the extent that the first respondent interprets Section 39(2) and 3 of the Election Act and Regulations 83(2) and 87(2)(c) to mean that it can confirm, alter, vary, and or verify the presidential election results declared by the constituency returning officer, in particular constituency, it is contrary to Articles 86 and 138(2) of the Constitution and is therefore null and void. Close quotes. The appellant was aggrieved by the judgment and decree of the High Court and lodged in this court an appeal founded on 23 grounds, which ultimately they condensed into 4 broad grounds, contending that the High Court erred by A, misapprehending the law regarding the constitutional and statutory requirements for declaration of results of the presidential elections, B, declaring Sections 39(2) and 3 of the Act and Regulations 83(2) and 87(2), C, unconstitutional, null and void, C, holding that it had jurisdiction to hear and determine the petition, and
Apologize for that freeze of signal, but I think we have it back with sound. We'll take you back to the Court of Appeal.
Three issues, namely the difference between announcement and declaration of election results, the person responsible for declaration of the result in a presidential election, and the purpose and effect of sections 39(2) and 3 of the Act. On the first issue, Council submitted that to appreciate the meaning of and the difference between announcement and declaration of election results, the context in which the two terms are used in the Constitution and the Act must be appreciated. They contended that announcement of the election results as used in Article 86C of the Constitution and in the Act and regulations means making the results of an election publicly known. On the other hand, declaration, as defined in Black's Law Dictionary, 9th edition, means, quote, a formal, a proclamation, an announcement, especially one embodied in an instrument, close quotes. Relying on the judgment of the Supreme Court in Hassan Ali Joho and another versus Suleiman Said Shabal and two others, the appellant submitted that a declaration is a formal pronouncement in the election process by a person authorized either by the Constitution or the law to make the declaration, which pronouncement brings the electoral process to an end. Accordingly, it was contended that the appellant's chairperson, who is usually appointed via a Gazette notice to act as the returning officer in a presidential election, is responsible for declaring the results of that election. In the appellant's view, an announcement of election result merely publicizes without finality the result of a particular election, but the declaration of results has the effect of determining the outcome of an election and bringing the electoral process to an end. On the second issue, the appellant submitted that the Act empowers it to appoint returning officers to supervise the conduct of elections for various offices. The appellant further submitted that under Regulation 3(1), the constituency returning officer is appointed to supervise the conduct of elections for members of the National Assembly and the County Assembly, while the county returning officer is appointed under Regulation 3(4) to supervise elections of governor, senator, and woman representative. The appellant therefore contended that the return
All right, our apologies there, loss of picture, but I think we have it back, so let's head back to the Court of Appeal.
Presidential election, the returning officer is its chairperson. 138(3)(c) and 10, it was urged that the same vests a duty to declare the results of the presidential elections in the appellant and its chairperson. In the appellant's view, a correct reading of these provisions demonstrates that the constituency returning officer has no mandate to declare results of a presidential election. The appellant relied on Hassan Ali Joho and another versus Suleiman Said Shabal in support of the contention that it is only its chairperson who has the mandate to declare the result of the presidential election. Accordingly, in the appellant's view, the conclusion by the High Court that the results of the presidential election announced by the returning officer in the constituency are final amounts to extinguishing the constitutional mandate of the appellant and its chairperson. Turning to the third issue, the appellant urged that the Independent Review Commission, that is the Kregler Commission, appointed to investigate all aspects of the 2007 presidential elections in Kenya, recommended that election results be declared final only after proper scrutiny and verification. It submitted further that Article 138(3)(c), as read with Article 138(10), emanated from that recommendation, and that Section 39(2) and 3 of the Act and Regulation 83(2) were intended to give effect to those constitutional provisions. It was the appellant's further contention that the High Court erred by failing to consider and appreciate the purpose and effect of Sections 39(2) and 3 of the Act before holding that those provisions were unconstitutional. As regards the presidential election, it was the appellant's view that Article 138 is self-contained and that there is no need to look at any other provision of the Constitution. That article, it was submitted, does not apply to elections of any other office save the office of President, a distinction that the High Court failed to appreciate. Regarding Article 86, the appellant submitted that its purpose is to set out the constitutional principle that election results should be announced promptly, and that Article 138(2) does not provide for the manner of declaration of presidential results. The appellant maintained that in a presidential election, the only act that takes place at the polling station is counting and announcing of the results, with the verification and tallying being escalated upwards. Lastly, the appellant submitted that the constituency returning officer is not mandated to declare the results of the presidential election, that the High Court assigned to him a role not contemplated by the Constitution, and that upholding the High Court judgment would mean that in a presidential election there would be 290 returning officers, 290 declared results, and possibly 290 election petitions and 290 respondents, which would be impracticable and an absurdity. Moving on to the second ground, the appellant submitted that Article 138(3)(c) requires it to verify the count before declaring the result of the presidential election, and for that purpose, its chairman is required to tally and verify the count from all polling stations before declaring the result. In its view, the legal definition of the phrase "to verify" is, and I quote, "to prove to be, to confirm, establish the truth, or to authenticate," close quotes, and not to alter and or vary results as was interpreted by the High Court. It was the appellant's contention that ballot papers are election materials which must be accounted for, and that the confirmation, verification, and collation carried out by its chairperson is a control measure to ensure that what is received from the returning officer at the constituency tallying center, as provided under Article 86(b), is consistent with the election materials that were issued for purposes of conducting the election. According to the appellant, therefore, the collation, tallying, verification, and confirmation of presidential results is a purely mathematical exercise for the purposes of consolidating the results received from each returning officer, and that it is on that basis that the results are referred to as provisional. As regards the constituency returning officer, the appellant maintained that his role is to collate and publicly announce the results from each polling station in the constituency in a presidential election in line with Article 138(2), and to deliver it to its chairperson, the collated results, which he is in turn tallies and verifies in line with Article 138(3)(c) before declaring the result in accordance with Article 138(10). On the penultimate ground, the appellant submitted that under Article 163(3)(a), the Supreme Court has exclusive jurisdiction to hear and determine disputes relating to the election of the President. That jurisdiction, it was contended, was not shared with the High Court, and the High Court therefore erred in arrogating itself a jurisdiction that it did not have. In support of that submission, the appellant relied on the decisions of the Supreme Court in the matter of the principle of gender representation in the National Assembly and Senate, and Samuel Kamau Macharia versus Kenya Commercial Bank, and in the matter of the Independent Electoral Commission, and added that a presidential election involves a series of events and is not a one-off event.